morning started with a motion eliminate to prevent the use of the term alibi script. For someone like me who's never heard of this case, I found this interesting. The prosecution stated they didn't intend to use that term during the evidentiary portion of the trial, but they do plan on using it during closing. In the meantime, they will be called timelines. During the time the defense was talking, he mentioned that Michelle was of the belief that Fotis was driving around disposing of garbage because he was trying to evade laws on disposal of construction materials. This is actually a plausible explanation on why she wouldn't question him, especially if he'd done this before. The only witness today was Riley. They started with a search of the Ford Raptor. They searched this on May 31st. The defense made an objection to showing a photo of the Raptor in the police parking lot. That objection was overruled, and they go through the photos of the Raptor. The police sprayed luminol in the bed of the truck. Lots of objections from the defense on this. Just the mention of it. Several areas of the bed of the truck luminesced, so they performed KM tests on these areas. And it was hard for Riley to answer because the defense kept objecting. Turns out the results of the KM tests were negative. I think it's good that the prosecutor presents this. The goal is to get the facts out, and that includes facts that don't necessarily help the prosecution. That includes facts that are either neutral or even helpful to the defense. And I think it's good for the jury to see that the prosecutor is not omitting facts that don't support the prosecution's case. And you know what? If the prosecutor left out facts like this, what do you think the defense would be doing or saying about that? They sprayed the driver's side door with luminol. There was a positive result on the armrest below the door handle. Again, the defense objects and is overruled. Riley testifies that they then used the KM and it came back negative. At this point, the defense stands up and wants the judge to strike the testimony as irrelevant. And it is relevant, and in fact is not bad for the defense. And again, what do you think the defense would say if the prosecutor failed to bring this out? Ooh, the prosecutor is hiding things. You know that's what it would be. Police swabbed the steering wheel for DNA. Of course, we expect to find Fotis' DNA as it's his truck. And some people might think that swabbing here is a waste of time. But if they also found Jennifer's DNA, that would be important. And if they found somebody else's DNA or even an unknown person's DNA, that would also be important. You've got to remember, at the time that the police are looking into these things, they don't know what's coming. By the time we hear about it in the public, or by the time it gets to court, everybody has the benefit of hindsight. If, for example, Fotis later said, "Oh, my car was missing for a couple hours that day. My truck was missing." Or, "Oh, I lent my truck to so-and-so." Then all of a sudden, the fact that the police didn't swab that steering wheel is going to be important. Look at the interior of this truck. Look at the dirt on the floor and the untouched dust on the dash. I don't think this truck was used to transport Jennifer. That's just my opinion. And remember, I haven't heard anything about this case other than what's being presented in court. So I could be wrong, but I think if this had been used to transport her immediately after the crime, Fotis would have cleaned it. Also, given it was obviously not cleaned, one would expect to find some blood or bodily fluid on it then. This is a photo of an area of interest to police. They wanted to find out what this substance was, and that's as far as they went with the testimony about that. These items were part of the inventory from the truck. The gloves were found under the driver's seat. More items from the truck. In July, they went back to the Raptor, which by then was parked in the police impound lot. They were looking specifically for an Adidas ball cap and those gloves. Riley testified that on June 6th, they searched a Jeep Cherokee belonging to Fotis. Then the prosecutor goes through the process of getting other photos admitted, and the defense tries to cross-examine the witness during voir dire. He has done this repeatedly, and he's called on it. Even after he's called on it, he continues to argue about it. The judge didn't let him keep going with it, though. The defense then asked Riley the same questions as the prosecutor just asked. Then he again objected based on relevance. The prosecutor argued that the process of the investigation is relevant, and she's right. And then it comes out what the defense is worried about. He says it's about Fotis Dulos, not Michelle Troconis. I understand where he's coming from on that. I think he wants to sever this link in as many places and in as many ways as he can. He has a point that it's Michelle, not Fotis, on trial. But, as with any case where someone is an accomplice, what the partner did in the course of the crime does matter. The prosecution has a tough job here. They can't try the two together because Fotis is deceased. The judge points out that there is a difference between relevance and materiality. How material a piece of evidence is might not be known yet, but that doesn't make it irrelevant. The prosecutor continues to work through the process of getting photos admitted, and the defense makes the same objection and gets the same overrule. Here's the Jeep and the inventory of the cargo area, the glove box. Now that plate appears to be the same plate that actually belongs to the Jeep anyway. More items from inside the Jeep. In an earlier objection, the defense specifically mentioned a photograph that included a pink umbrella. And because he specifically mentioned that one, now it's got me wondering about this photo. Police also processed a 2015 Suburban owned by Fotis Dulos. The prosecutor went through the process of getting the photos admitted. When they got to the one related to luminol, the defense objected and said, "We've had this conversation before." Yes, and you were overruled. You know, I think the defense is laying the groundwork in case he needs to appeal. Then he can show how many times he objected in specific areas. I don't know that. It's just what pops into my mind. Anyway, the objection was overruled again. The defense continues to make the same objections and then adds more argument to the same objections and is overruled again. This is the Suburban belonging to Fotis. Riley said this was luminol. The defense objects. The defense kept objecting quite vociferously, making it difficult to move along. When they showed this picture of the luminol cargo area, the defense became even louder about it. The prosecution asks about the results of the luminol, and the defense objects to the term results. The luminol reacted to an area, a KM test was performed, and it came back positive. Here are the inventory photographs from that Suburban Fotis'. They moved on to a search of 585 Deercliff. If I'm understanding correctly, it is a house owned by Fotis' company. If I've got that wrong, let me know. Testimony was the house was in a state of disrepair and was unoccupied. Police searched it on June 4th and they brought along canines. They're still looking for Jennifer. The for sale sign there is for that property. Considering the weeds there and the pile of what appears to be dried plant matter, it looks to me like this garage hasn't been actively used for vehicles for a while. Both the garage door and the door to the house were unlocked. If Fotis was hiding anything in there, you'd expect it to be locked. He'd want control over that. If the police do find evidence in there, the defense can argue that because it was unlocked, anybody could have left the evidence. At the time I'm looking at this, I don't know if they've found anything. Here's the interior of the garage. The Porsche inside appeared to have sustained collision damage, according to Riley. More inside the garage. Another picture of the Porsche. Riley stated that they noticed airbags had been deployed and the 2 front seats were missing. More from inside the garage. Here's inside the kitchen of that house. They searched the whole house. They spent, I can't remember, I think they said 8 hours there and found nothing of any evidentiary value. Then they moved on to search 80 Mountain Springs, and that search occurred on June 2nd. Here's an aerial view of the property. Here's the entrance to the driveway. The driveway is crushed stone. I have no idea whether that will come up later or not. This house was also unoccupied and contained no furniture. This search did take 8 hours. Riley opened the lids on the propane cylinders in the field and the lid of part of the septic system. So he looked in the septic system. He was looking for any traces of blood or clothing or fiber, anything that shouldn't be there. They found nothing of any evidentiary value. They went on to search for Jefferson Crossing. Inside this black bag, they found a portable hard drive and 3 photocopied pages of a handwritten note. That's how they described it. It's basically a detailed timeline of what someone did starting on the Friday before Jennifer's disappearance. They had Riley read as much as he could make out. One of the things that jumped out at me is the note said, took shower together. If it said, took shower with Michelle or took shower with Fotis, that would make more sense. Saying together looks like either this was an agreed upon descriptor, like we'll say we took a shower together, or something that one person wrote out and wants the other person to say. This alone is not conclusive of that, but it does stand out. Whoever wrote this misspelled cereal. The defense objects to Riley reading the note and blurts out, "That's not even my client's handwriting." The judge admonishes him gently, saying, basically, you're testifying, you're not supposed to do that. This already looks like a plan to get stories straight, but it also appears to be conceived and authored by Fotis. To write out a timeline or alibi is actually not bad if the thing is true. In fact, it's often recommended by lawyers and even police officers. Look, write down everything you can remember about that day or the previous days up to and then afterwards. So having something like this isn't necessarily bad. The thing that's jumping out here at me anyway is the language. And the language suggests, or the use of the language suggests this is not simply making a record of what is remembered. Now, I can't say that conclusively. On the next page, there's a list of phone calls. And I'm not a handwriting analyst, but it looks to me like this is different handwriting. There's a line that says, Fotis incoming. Well, who wrote this page of the note? If Fotis and Michelle sat down and wrote this together, rather than each writing out their independent recollections, that could explain the language and could still be explained by them taking advice to write out their recollection. If you're ever asked to write out your recollection, don't do it with anyone else. Memory is more flawed and fallible than most people think, and people influence each other. This is page 3. This is obviously in relation to Michelle's activity. The language here is more normal too. There's still a plausible explanation so far. Then the police found another note that was similar. This one was found in the office. This one had additional writing on it, and it was not a photocopy. The difference in content between this one and the other one is that there's a list of phone calls on the right-hand side of this one, It looks like Fotis wrote his phone calls on the right of his original document, while Michelle wrote her phone calls on a separate sheet. And I'm making a leap here, assuming that Fotis wrote the original note. I mean, everything points to that, but I could be wrong. So it looks like Fotis photocopied it, gave it to Michelle, then they each wrote their own phone logs. Really, you could argue this in multiple ways. Next page. Then the state introduced a box of trash bags from the kitchen of Jefferson Crossing. And they didn't go further with that. They just introduced the evidence. On cross, the defense is talking about the box of trash bags. He opens the box. He's asking questions about how the bag, it's in a roll and you have to stick your fingers in there to get a bag out and all of this. And he's touching the bags and he's unrolling and pulling out a bag and handling the crap out of this garbage bag that was enclosed in this box without any gloves. The defense brings out that Riley does not actually know who wrote the second document. Other than the gloves and the hat that was seized, nothing was seized from the Raptor or Jeep. No personal belongings. So they took swabs and everything, but no personal belongings. From the Suburban, no personal belongings except the WeatherTech liner. The defense says the witness didn't show pictures of the entire house at that one rundown house. But the defense had complained earlier that they were putting in too many pictures. In respect to 80 Mountain Springs, the defense says, were there no stains on the floor? And Riley says, well, yes, there were. Then the defense goes after there was a coffee cup in a recycling bin. The defense is saying, well, were there no stains on it? Did you smell it? Did you take a picture of it? And the answer was no. On the one hand, he's saying, you're introducing too many pictures, they're not relevant. And now he's saying, well, you didn't take a picture. You see, in respect to the stains on the floor, they actually did test it. And they tested negative. And I got a note here that if the prosecution had asked this question, the defense would have been on his feet, hollering about it. The defense pointed out these stains in the gravel of the driveway at the Mountain Springs house and pointed out that the police did not collect those. The defense spent so much time complaining there's so many exhibits, too much information, not material. Oh, he actually said not relevant. Meanwhile, the detectives who, they actually do this for a living, determined certain things weren't relevant. The defense is going to complain about that too. They can't win. The defense then brings up the septic system and asks, well, did you have it pumped out? And Riley says, well, yes, we did. Then the defense says, oh, well, I see there's a ladder in there. And Riley sitting on the witness stand, he starts grinning because he knows what's coming, right? And so the defense asks Riley, did you go down the ladder? And no, he didn't. The defense asks if this pink tape was seized. The answer was no. Remember on the second note, there was pink tape along the edge, different location. I think that Mountain Springs was searched before Jefferson Crossing, and so that pink tape would not grab their attention. And of course, now that I'm recording, I can't find the date. But I do believe that 80 Mountain Springs, where the pink tape was searched prior to them finding that note. So they would have no idea that pink tape of any kind could mean anything. But they are both locations that Fotis had access to. The defense asked if the police tested the garage floor at Mountain Springs. I note again, only because the defense is objecting so much. So I'm going to say again, if the prosecution asked this question, the defense would be on his feet, objecting his head off. The answer is yes. They did test it. They luminoled portions of that floor. This is almost comical. The defense is doing exactly what he complained about the prosecution doing. So the defense moves on. He points out that some of the property is part of the office. The defense asks if the police tested this floor, and the answer was no. Or this floor with obvious oil stains on it, and the answer is no. Like, buddy, they're looking for things like blood or bodily fluid. Of course they didn't test an oil stain on a garage floor where it would be expected. Had there been a big oil stain in the middle of the bedroom, somebody might have noted that. Defense asked who else lived at the Jefferson Crossing residence and who else was staying there. And Riley didn't know at the time. All the vehicles that were searched, I say they belonged to Fotis. They were technically registered to Fotis's company. And that was pretty much it for today. I think there have to be more questions asked about the notes. That's it for today. Trust your gut. I'll see you in the comments.